anyone remotely familiar with auditing videos will be very aware that when an auditor enters what is clearly private property, they cite Section 33 of the Criminal Justice Act 1972 and quote its definition. When an auditor does this, they are attempting to use the Section 33 public place definition to provide a legal justification for entering private property, just because a gate is open or a barrier is up. However, this is a total misrepresentation of the Section 33 definition, which is actually an updated interpretation clause that defines a public place for offences committed under Section 9, subsection 1, of the Public Order Act, 1936. Such Public Order Act offences include the wearing of political uniforms in public meetings and the prohibition of quasi-military organizations. The linking relationship between the two acts very clearly appears above the Section 33 definition. This means the Section 33 public place definition that auditors parrot from the auditing script is nothing whatsoever to do with public access rights to private property. So, when you watch a clip uploaded by an auditor, and they pull out the same, tired old Section 33 public place definition that they claim allows them to enter private property, they are quoting from a totally unrelated act and section. A biscuit factory does not suddenly become a public place because a gate has not been shut. Show them the door, and if they refuse to leave, simply eject them using reasonable force.